State versus Leyman, and both sides will have 15 minutes to present their arguments, and you may reserve up to 5 minutes if you so desire.
Thank you.
Thank you.
We would like to reserve 5 minutes for rebuttal, Your Honor.
Thank you.
Thank you, Your Honor. May it please the Court, my name is Stephen Hannadell. I represent the appellant Donald Leyman. This appeal concerns, it's from a denial of a post-conviction relief petition, as well as a motion for leave to file a motion for new trial. The post-conviction relief petition alleges constitutional due process violations because Mr. Leyman, before the trial, did not receive the written police reports, which there were 2 of them, and he did not receive the audio recording of the interview with the children and the mother. He was totally unaware that they had interviewed the mother and even had a recorded interview with the mother. The only awareness that he had of the interview was that he was provided a transcript, albeit a haphazard transcript, of the children's interviews that didn't capture all the words spoken. And he did fight hard before the trial to obtain the audio recording, but all he was given was a transcript of the children's interviews. Well, now that we have the full written police reports, and we have the full recorded interview, which I had transcribed by a court reporter that captured the quote-unquote inaudible portions from the old transcript, as well as the mother's interview, we now know there are some serious discrepancies in the big lie that was perpetrated by the mother and the 2 former stepchildren. And whenever there is a big lie, there are going to be holes, and there's plenty of them in this case.
Before we get to those facts, perhaps you could address the initial decision that this court has to make, and that is whether or not your client meets the terms of having not being able to reasonably
the unavoidable prevention?
Yes.
Well, first of all, as I filed on a notice last week, there is an issue, I think, with the recent 6th Circuit decision of Gunner versus Welch, where if the defendant is not advised by the appellate counsel of the 180-day deadline, that would be ineffective assistance of counsel, and therefore the 180-day rule would not apply. That's kind of a separate issue because that case was not out at the time that I filed a petition and didn't come out until shortly before the petition was denied by the trial court. And that, I think, would affect the scope of any of this court's remand to the trial court to discover whether my client was advised. But putting that aside, I don't think it's going to be an issue anyway, because this court had held in State versus Covender in 2012, in December 2012, a case out of Lorain County in which Mr. Covender was recently acquitted of the child sex offenses in October. This court had held that the unavoidable prevention of discovery does not mean that you have to go on a desperate fishing expedition, meaning you can't be made to look in places that you cannot reasonably anticipate to find anything. So like in Covender's case, he had sought the therapy records of the children, and the trial court had looked at them before and made its own determination. Well, they're not going to help you, so we're not going to let them be released. Well, when he finally did get his hands on them, in the late around 2010, 2011, and it showed that it did make a difference, this court had held that because Covender did everything he could before trial to obtain that information, but was denied. And given that the court had told him, well, if these don't help you, he could not reasonably anticipate that those records would yield any different information versus what the court told him.
But I
think that applies here.
That he also did everything he could after having been convicted. He was continuing to make contact to the extent that he could with witnesses.
Well, and that helped because Covender was released on parole in 2007. So he didn't begin his post-conviction efforts until he was released out of prison. My client's still in prison. He's closing in on 17 years of incarceration when he first got arrested in June '98, back when I was in high school. So that's how long ago this was. So, and it's very hard for anyone sitting in a prison cell when all they're given is a pad of paper and a pen. They have very limited access to the internet and it's very difficult to have communications. They have to pay for their phone calls and so on and so forth. Very difficult to make contact with the outside world to get anybody to help. And
well, is the record going to show that he made any efforts that would assist him in that regard from the standpoint of, from reading the briefs, it looks like, I can't remember if it was
He did swear an affidavit.
2013, that he retained a private investigator.
Yeah.
Okay. Is there anything in the record to demonstrate that he attempted to do that at any time within those years?
That he swore to an affidavit that generally spoke about, after, I mean, he fought on direct appeal. He appealed pro se to the Ohio Supreme Court. They declined jurisdiction, and then you had the help of the Ohio Public Defender through a federal habeas corpus effort, which they basically just mimicked this court's holding in the direct appeal. And after that, I mean, he hit a dead end. And so, he swears in his affidavit that he did write letters, asking for help, whether it's through the Innocence Project or other organizations. But, unfortunately, he wasn't able to obtain any help. And so it's, when his resources are that limited, sitting in prison, I think it wouldn't be fair for the court to subject him to a high standard in terms of the effort, because how can you make the effort when all he can do is just write letters?
Well, I'm not suggesting that he be put to a high standard, but if we even look at the standard that he has set in 2013 by retaining a private investigator, that if we apply that standard,
well,
and then take that back over those years.
I mean, and that was through his family. His family provided those resources. It wasn't him directly. And so,
are we going to find that in the record?
Yes, that should be in the affidavit. And so, he has no control over what third parties do with their resources in terms of their voluntariness to help. And so, by himself, it's extremely difficult to make those efforts from a prison cell. And especially too that he has every right to assume that the prosecutor fulfilled his constitutional and ethical obligation to provide all the relevant discovery that was compliant with the constitutional mandates of Brady versus Maryland and all of his progeny. And so he has no reason he shouldn't have no reason to think that, oh, they held something back that would have been useful at trial. And that he has every right to that presumption that the state fulfilled its obligation. And so it's not until we uncover the police reports, the unredacted police reports, which and as well as the audio recording, that you start seeing the discrepancies where had that knowledge been available to him before trial, it would have made a difference in the trial. And also too on that standard, the U.S. Supreme Court had made very clear in Kyles versus Whitley that when you evaluate the materiality of the new evidence or the recently discovered evidence, you look at does it undermine the fairness and the outcome of the trial. You don't reweigh it, you don't measure, oh, does this somehow render the conviction insufficient or anything like that, and you don't conduct a harmless error analysis either. All you're looking at is, does this undermine the confidence in the outcome? Can we feel good that this outcome was just? And if the answer is no, then it mandates a new trial. And it doesn't matter, whether he would have won or wouldn't have won or anything like that. All we're concerned with is does this evidence put in light with the overall facts and circumstances, create an issue of fairness and confidence in the fairness and the outcome of the trial.
Now, perhaps you should speak to how you believe the evidence did so.
Yes, and again, we don't conduct any reweighing or harmless error analysis or the evidence sufficient or anything like that. We're just concerned with, okay, does this raise a question mark, a genuine question mark on the outcome of the trial? And if the answer is yes, we do it over again. And in particular, and I'll just give some of the particulars of the very first police report when these alleged acts were reported. And mind you, there was never any medical, physical, or scientific evidence ever presented to substantiate the allegations. These were totally based on the oral allegations of the children. And as for the stepson, they never even established the location or the time as to when this happened. So, in my opinion, this should have been thrown out on Rule 29 in trial, and because of insufficiency. They never established the location of the rape of the stepson, and they never established the time frame of the alleged rape too. So, And in my opinion, that should have been rendered insufficient evidence, but that's, now we're here. But in the very first police report, the children didn't even allege rape. All they alleged was just inappropriate touching. And in the post-conviction petition, they have an expert opinion which she opined that, the fact that when children, when they start disclosing allegations and, the alleged perpetrator is not around, for them to withhold the most serious aspect of the allegations she feels is not reliable. Because there's no reason for a child to just, only talk about the milder form of the allegation and not the more serious one.
Counsel, you are starting your rebuttal time. If you want to continue, that's fine.
What's that?
You're in your rebuttal time. If you want to
Okay,
continue,
then I'd like to
that's
save
fine.
for rebuttal. Thank you.
You may proceed.
Thank you, Your Honors. May it please the Court, my name is Matthew Kern. On behalf of Dean Holman, the Medina County Prosecuting Attorney, I represent the state of Ohio in this matter. I'd like to start with a couple of framework issues first. I know there's 4 assignments of error. They generally split along 2 kind of divisive lines. One is the post-conviction petition denial, and the other is the 33B new trial motion denial. There's a 4th grand jury transcript issue that I'll touch upon at the end if I have time, but otherwise the brief, I think, is more than sufficient. The framework issue is this. You've heard a lot of argument this morning from Mr. Hanadel about the merits. The trial court in this case, however, visiting Judge Richard Marcus, denied the petition as untimely, and he did so applying the abuse of discretion standard, which is, as the court knows, is the controlling standard of review. The transcripts were filed in the direct appeal on July 14th, 1999. 180 days after that, under 2953-21, but the post-conviction petition was due on January 10th, 2000. The petition was actually filed in this case on October 29th, 2013, or more than 13 and a half years after it was due. This is uncontested. The court, as it well knows, in State v. Tays and State v. Hoffmeyer, some county decisions 2013 and 2011 respectively, has held that the trial court lacks jurisdiction to entertain untimely petitions unless they meet the savings provisions in 2953-23A, in which the only one in this case that applies is whether the defendant was unavoidably prevented from discovering the facts upon which the petition relies. That is the crux of the issue before the court. But even more fundamentally than that, the fundamental framework debate in this argument today concerns merits versus procedure. And in this case, the defendant has made several attempts to put the merits in front of the procedure. He argues his supposed actual innocence as a standalone constitutional claim, which somehow bypasses the limitations periods on 2953-21. He argues Brady violations that didn't happen as a standalone basis to bypass the limitations period in 2953-21. These are limitation jurisdictional issues that precede any merit consideration that the court can do. If the court determines that the petition was untimely and that the arguments, that the evidence upon which it relies was not, that the defendant was not unavoidably prevented from discovering it, that's it. The court has to affirm the trial court. If the court determines that the defendant was unavoidably prevented, then you should reverse and remand for the trial court to make those determinations in the first instance, because the trial court never passed on the issues. All of the merit issues in the trial court's opinions are in the alternative. They are not primary holdings. The court didn't have an evidentiary hearing. The court didn't assess the full weight of the defendant's petition, the state's response, any surreplies. No, there was no evidentiary hearing. There was no status hearing. There was just petition, the state's response, defense motions, the state's response to those motions, and then a decision. The trial court never actually weighed the merits of the issues and made a reasoned conclusion based on the evidence. He reviewed the record, found that the record was either showed that the defendant's arguments were barred by res judicata in some instances, or shown by the trial transcript record to not be supported based on his evidentiary claims. But the court didn't make a merits decision in the first instance. The court made a procedural jurisdictional determination in the first instance. It would be wholly improper in the state's view for this court to weigh in on the merits, as Mr. Hanado wants you to do. and usurp the role of the trial court, which never really did that in the first instance. So, with due respect to counsel, I will respectfully refuse to answer merits questions because I think they are improper at this juncture. If you like, I will answer to the best of my knowledge based on the record, but that's the entire point. The record does not contain answers to a lot of the questions this court wants to ask, right? His affidavit, filed 13 and a half years after the post-conviction petition was due, is self-serving. Of course he's going to say that he never made contact with anybody, that he did the best he could, but somehow he managed to find a private investigator. Mr. Handel tells you today that's because the family paid for it. If so, why couldn't that have happened sooner? Clearly, Mr. Leyman was in continuing contact with his family during his incarceration. Why is that not an unreasonable delay in proceeding to try to vindicate your constitutional claims? This court has held that the defendant must make reasonable efforts to timely file. State versus Davis, 2013, Ohio 846. State versus Cleveland, 2009, Ohio 397. The defendant cannot just sit idly by, wait to happenstance discover something he thinks shows a constitutional violation, and then file whenever he wants. Finality does not come easy in the criminal justice system, but at some point it must arrive, and that point is now. There's another fundamental framework debate here is about the standard of review for post-conviction petitions. Mr. Handel claims that because there was no evidentiary hearing that this court's review is de novo, and he says that the denial is like a 12b6 motion. Well, first of all, post-conviction petitions are statutory proceedings, not civil proceedings. The rules of civil procedure do not apply. That's the 6th District State versus Darden and a published Ohio appellate reporter's decision cited in the state's brief. The other thing he overlooks is that the Ohio Supreme Court, in this very procedural context when there was no evidentiary hearing, has held that the standard of review is abuse of discretion. In State versus Calhoun, 86 Ohio State 3rd, 279, the Supreme Court said that the standard of review for post-conviction petition denials is abuse of discretion. And this court has followed that in these very procedural contexts several times. State versus Logan, State versus Maruna, State versus Glenn. So, clearly the court's review is for abuse of discretion, not de novo review. Really, the fundamental debate as for the unavoidably prevented argument boils down to the defendant's reliance on Covender, the Lorain County case. The facts in Covender are easily distinguishable, as the 8th District found in State versus Williams. They're similar circumstances what the defendant claims. This case happened in the late 1990s, prior to the July 2010 amendment to Criminal Rule 16. He claims that we never provided police reports, that we never provided audio recordings of witness interviews, that we never provided additional information. It wasn't owed. We complied with Criminal Rule 16. If something was potentially discoverable, we gave it up. The insinuation that because we did not provide police reports, that because we did not provide recorded interviews, that because we didn't provide written witness statements, that we somehow violated Brady versus Maryland and other criminal discovery rules is unfounded, because Mr. Handel seems to be forgetting that we didn't have to provide it then. We read police reports to defense counsel during pretrial conferences. That's uncontested in this record. And we did, in fact, give the audio recordings of the interview to a defense expert. So to say that we never gave it to the defense is actually belied by the record. That claim is flat wrong. But in Covender, the police reports were not disclosed in discovery. And the trial court dismissed the post-conviction petition, saying you weren't unavoidably prevented from discovering the facts. Right? The argument is you knew you didn't have the police reports. What stopped you in 13 and a half years from asking for them? Nothing. At some point, once the conviction became final, the reports were arguably public records under 149.43.
Wasn't his statement though that he got redacted records?
Redacted.
Able to get unredacted records?
The only thing that the public records redacts in those kind of situations is Social Security numbers, and if it's the defendant making this request, I mean, you're free to inquire. Mr. Handel, he got them in a public records request. You're free to inquire how he received them. We do it the same way for every case. The only thing that we would really redact in those situations is potentially names of minor victims and anything required to be redacted under the law, including social security numbers, personal identifiers, and the like. Nothing, nothing about the public records disclosure prevented him from discovering the facts. The best argument that he has in terms of the non-disclosure is the witness statement or interview of the children's mother, his wife. That's the best argument he has, because that wasn't transcribed, but it was on the same recording as was turned over to defense counsel, or to the defense expert. So it was provided. So he stands up here and he makes a lot of arguments about how the state violated Brady and progeny, Kyles versus Whitley. We provided discovery. We provided materials. We gave up the interview. For him to claim now, 13 and a half years later, that I was unavoidably prevented from discovering these facts because I didn't have access to my now ex-wife, it strains credulity. What stopped him in 13 and a half years from writing to her? What stopped him in 13 and a half years from trying to contact his son to try to get the alleged recantation? And that's the other thing I take issue with, is he claims that both Mr. Hanadel had a conversation with the witness, and that the private investigator, Mr. Majoy, had a conversation with this witness. And they claim that in those conversations, the witness recanted. Now, what's notably absent from the post-conviction petition? An affidavit of the witness actually recanting. Instead, they characterize it as, I went to his house, I talked to him, and I said, this didn't happen, right? And he remained silent. Now, is it possible that the witness's silence was actually intended as a recantation? To be fair, theoretically. But is it more likely that the witness just wanted the investigator out of his house so he could go on with his life, and so refused to answer? Because as the investigator notes, he was reluctant to answer any questions. It wasn't just on this one particular issue. What's more likely? An investigator for the man who raped you 20 years ago comes to you and says, it never happened, right? What would you do? Put yourself in his situation. So, the claim about witness recantation is a stretch. The claim about a Brady violation, shown by the record not to be true. The claim about the state hiding evidence, turns out that we were just complying with the rules of discovery all along. All of these are the insinuations the defense counsel makes in support of his claim that we somehow did something so improper that he was unavoidably prevented from discovering those facts. It's not true. It's not true. The other claim he makes to avoid the jurisdictional limitations period in 2953-21 is that he is actually innocent. 2 points on this. One, the U.S. Supreme Court recently in McQuiggins versus Perkins has held that it is not a standalone constitutional claim. And second, this court specifically held in 2012 that claims of actual innocence do not excuse non-compliance with the limitations period in post-conviction proceedings. That's State versus Hutzler in 2012, Ohio 6107, paragraph 10. The other thing he claims is that the witness recanted, and that's a constitutional violation. This court has specifically rejected that challenge in State versus Cleveland. Even if the witness actually recanted, that is not a constitutional violation. Unless he also shows, argues and shows that the state was aware that it was a lie back when it solicited the testimony, and shows that it nevertheless elicited the testimony, is that a constitutional violation? A witness recanting their testimony does not actual innocence make, and does not a constitutional claim make. And I've already argued about why the witness recantation claim is potentially not accurate. There are some miscellaneous issues, but primarily Mr. Handel keeps trying to argue the merits, and this is a procedurally improper argument. I can spend some time on the new trial issue, but really the unavoidable delay language and the unavoidably prevented language are mirror images. Courts around the state have used the same cases and the same standards to evaluate denial of one and denial of the other. There's nothing new. The 9th District in McIntyre, 2011, Ohio, 3668, paragraph 2. He could have written witnesses, he could have written to additional people, he could have hired the investigator, he could have contacted Mr. Hanadel earlier. He didn't take any of those steps. Instead, he waited for 11 to 12 years before doing anything further in his case. And even after Mr. Hanadel made contact with the victim and claimed that the victim had recanted to him, I guess making himself a witness in the case, arguably, but even after he recanted allegedly to Mr. Hanadel waited another 1.5 years to file the petition. Now I grant you that it takes some time. Would you please stop that? It takes some time.
Go ahead. If you have a problem, just address it to me and I'll take care of it, okay?
It was extremely annoying, Your Honor. I'm sorry. I grant you it takes some time to prepare the petition, to get things moving, and to file it. A couple of weeks, maybe even a couple of months at the most. But 1.5 years from when you think the main key witness in the case supposedly recants to your lead counsel for post-conviction efforts, too long. This court in State v. Davis and State v. Cleveland has held that petitioners are not only on notice that they have to be diligent in their efforts to find evidence, they have to be diligent in their efforts to file. And that's not shown in this case.
And counsel, you're right.
I appreciate that. Thank you, Your Honor. I respectfully ask the court to affirm.
You have about 4.5 minutes left.
4.5 minutes, thank you. To address this notion of my client sitting idly by, I don't know if anybody in this room has visited a prison before, but I have many times in this case, and I can tell you just, after 3 hours of the maximum visitation, I have enough, and wanting to get out. And so this notion of my client sitting idly by and, that somehow he's like enjoying his stay there, I mean, nothing can be further from the truth. I mean, it is not a picnic by any means to be there. And so, if he could have, obtained this information, much longer ago than he did, he would have. I mean, believe me, I don't know of any inmate who would sit there behind concrete walls and with plastic chairs and tile floors and in prison jumpsuits and think, oh, you know what, I'm enjoying my time here, I think I'll just wait and just hold off on pursuing and contesting my conviction. The circumstances are what they are, and given his limited ability and limited contact with the outside world, when he's in prison, it makes it extremely difficult for him to challenge his conviction, especially of a man when he has no resources and he's got to he's writing letters to organizations or contacting his family and see what they might be willing to do. So this notion that he would sit idly by, that is just not fair at all to judge anyone who's behind prison walls and barbed wire, that somehow that they enjoy their stay enough there that they'll just deal with it later. And as for the timeline, Mr. Leyman does lay out in his affidavit the timeline of when the case started to get going, and I can tell you from my personal experience in working on this case that this is unique. This is not your typical criminal case or even civil case. I mean, there's so much investigation that has to be done. There's so many loose ends that have to be pursued. There's so many angles that have to be researched, because this court would know it's often defendants have a very high hurdle to challenge their convictions, and so they really have to get it right, and they're not given much opportunity to do it again. And so as far as to why this petition got to be this thick is because when I see mountains of case law that say, well, you didn't attach this or you didn't enclose that, and therefore we're throwing it out because it doesn't look like it has any merit on its face. Well, that's the reason why. And so it takes time to build something like this and to make sure that all the angles are checked out. And so I don't think it's fair for anyone to judge the exact time frame to say, oh, you could have done this sooner or later.
But nonetheless, that's what the case law says.
But
nonetheless, that's what the case law says.
Yeah.
So we are to judge that and determine whether it was reasonable or not, if he could have done
that is
something.
true, but I think the case law has been rather harsh, and I think unduly harsh, because.
But on the other hand, you have to weigh that. I understand everything you're saying, but you have to weigh that with the finality of these decisions and the impact that it has on victims.
Well, given the insufficient evidence in this case, I think the children are victims of their mother, not of Mr. Leyman, and I strongly feel that way.
That's your personal opinion. I understand that, sir.
And I think when they can't even establish even the room or the house or the city or even the month or the year of when any of this happened, I think that raises a lot of question marks, and this court held in State versus Morris that when the evidence is weak to begin with, and it doesn't take much to in terms of influencing the outcome as far as new evidence or extraneous evidence that shouldn't be admitted and so on and so forth. And so it doesn't take much to throw the outcome in flux and to warrant a new trial. And I think the evidence in this case to begin with, as far as what was presented in trial in the first place, was weak enough. I mean, weaker than what was presented in Morris. And so now that we have more information in terms of what was alleged even before there was the indictment, and statements that were obtained since, when you mix it all together, there are some serious questions about the veracity of these allegations, and I think enough to where he should receive a new trial.
And you're out of time.
Okay.
All right.
Thank you.
Thank you. Thank you very much. The court will take the matter under advisement. The written opinion will issue and be sent to the parties, as well as you can check on the Supreme Court website.
Thank you.
Thank you. Thank you, gentlemen.